Hello friends, in the series on income tax cases, today we will discuss a very important case which is related to the application of seized or requisitioned assets. Meaning thereby that if there is a search on the assessee and in that search if the assets of the assessee are seized, so when the assessee can make the application to the department for the release of those assets, and when the department has to give back the assets to the assessee, this issue has been decided by Rajasthan High Court, Jaipur bench in the case of Kanwaljit Kaur and another versus Deputy Director of Income Tax Investigation. And this case is reported in 484 ITR at page number 784, and the date of the judgment is 21st August 2024. In the present case, the cash of rupees 34.02 lakhs which was in the locker of the assessee was seized on 21st September 2023. When this cash was seized, the assessee within 1 month from the date of the seizure made an application to the revenue to release that cash. In the present case, when the seizure of that cash was taken place, the assessee has already intimated to the department that there is this much of the cash in the locker of the assessee. That is before the date of the search on the assessee. When the assessee made the application according to first proviso to section 132B for the release of the assets, the department didn't dispose of the application of the assessee, and the assessee filed a writ petition in the Rajasthan High Court that according to second proviso to section 132B, the cash of the assessee is to be returned back within 120 days from the last date of the authorization for search under section 132. When the Rajasthan High Court heard the writ petition of the assessee, the court said that according to first proviso to section 132B, there is no timeline given for the release of the cash. Further, the court said that as per second proviso to section 132B, the cash to the assets of the assessee cannot be released until and unless the satisfaction of the assessing officer is recorded for the tax liability of the assessee and for the release of the assets of the assessee. The court further says that the satisfaction of the assessing officer can be recorded only when the assessment has been completed. The court said that since in the present case no assessment has been completed by the assessing officer, so as per first proviso to section 132B, it cannot be said that the satisfaction of the assessing officer has been determined or recorded for the liability of the assessee and for the release of the assets. Since satisfaction has not been recorded as per first proviso to section 132B, so the assets cannot be released according to second proviso to section 132B. The court further said that since in the present case the assessee has suo motu come to the revenue and explained that there was cash of rupees 34.02 lakh in the locker of the assessee, so the assessee has come with the clean hands. So in the present case, the court directed the revenue to dispose of the application of the assessee for the release of the cash within 4 weeks, and the court said that if the revenue feels that there is no tax liability of the assessee, then the cash can be released to the assessee with interest according to section 132B subsection 4 clause A and B. Friends, this case is important because this case throws a light that how the second proviso to section 132B operate. Section 132B second proviso says that the asset should be released within 120 days from which the last of the authorization for search has been executed. But the second proviso will trigger only when first proviso has been implemented, and first proviso will be implemented only when the AO has determined the liability. When the AO will determine the liability only after the assessment. So basically, if we do the harmonious reading of first proviso and second proviso of section 132B. So that says that the assets of the assessee can be released only after completing the assessment of the assessee when the tax liability is determined. If the seized assets are more than the tax liability, so the remaining amount should be given to the assessee after paying the interest to the assessee. At the end of this video, once again I am repeating the name of the case. The name of the case is Kawaljit Kaur and another versus Deputy Director of Income Tax Investigation, and this case is reported in 484 ITR at page number 784, and the matter has been decided by Honorable Rajasthan High Court on 21st August 2024. Thank you, friends.